Okay, this is part two of appearing in traffic court, and I think I left off about where I've explained who's in court and what the job of each person is in court, or what the responsibilities are of each person that's in court. And I also talked about the police officer presenting his case or her case, if that's the prosecution's case that'll be presented in court. And after that, if you have questions of the officer, you can ask those, and the judge will tell you when it's appropriate to ask questions of the officer. Don't interrupt the officer while they're testifying. You don't want to say anything to them, make any noises or gestures or anything like that. You can listen and take notes, and that's about all you need to be doing when the officer's testifying. When you ask a question, it needs to relate to the case, obviously. You need to have somewhere to go with it. And if you're asking about what the officer's vacation plans are or something like that, pretty soon the judge is going to say, look, I don't see where the relevance of that is, and you need to move on to another line of questioning. So ask questions that relate to your case or that will help you prove your case. Or don't ask any questions. You don't have to ask any questions of the officer if you don't want to. And then when that part of the case is over, then it will be your turn to present your case if you want to. And you can rest your case at that point and say, Your Honor, I'm not presenting any evidence or any testimony. Or you might have some evidence you want to present, but you're not going to testify, perhaps. Or you might want to testify if you believe that you're factually innocent, especially. Or you could also point out at some point there probably will be a chance for closing arguments, and you can ask the judge to be sure, will there be closing arguments, or will I have a chance to make an opening argument at the beginning, obviously, in that case. And some judges allow opening arguments, and they really should. It's pretty much standard in courts and trials, but a lot of times they don't. And one reason that they don't is because a lot of defendants don't want to make one. They don't feel comfortable making one. They won't make one, even if the judge gives them a chance to. So anyway, ask if you can make closing arguments. If you're not going to be able to make closing arguments, then in your presentation of your case, you really want to present your arguments at that point. Try to get those in any way you can, so that the judge has, at least has your rationale for why you think you're not guilty or why you shouldn't be guilty. And then at the end of the case, you can also request traffic school, especially if you asked earlier, am I eligible for traffic school? The fact that you went through a trial should not affect your eligibility for traffic school. And if you're respectful in court, and if you present your case well, and you're not argumentative, and you're not unpleasant to be around or to have in the courtroom, then I think the judge is very likely to say, yes, I will allow traffic school, or, no, I won't. And in either case, you don't lose anything by asking the question. You may not want to go to traffic school. You may not be eligible for it. If you've been in the last 18 months in California, then you're probably not eligible for traffic school. Or if your offense is particularly dangerous, there might be situations where you're not eligible for traffic school. But I always ask the question, and there might be situations where ordinarily traffic school is not allowed, but where the court has discretion to allow traffic school. And if there are, you want to ask the court to allow it, and just say, I respectfully request traffic school, and maybe the judge will let you do it, maybe they won't. Anyway, then at the end of the case, one thing you do have is a right to a decision on that day. Under California law, you have a right to a decision by midnight. Normally, that decision is made right there in the court. There might be a case where the officer says, look, I have some things to look into. I have some research to do. I have some things I would like to check on the case, and I'm wondering if the defendant will either waive the right to a decision today, or waive the right to, or just come back for your decision later on today, or I'll mail you your decision in the mail. Any of those options are good options. And if you're offered one of those options, I would take it, because what that means is that the judge thinks that you raised some important issues, and you might have raised some credibility questions about the officer's testimony, or the officer may not have proved their case, or the judge might believe that you're factually innocent and may not want to say that in court, may not want to challenge the officer in court or make the officer look stupid or anything like that. And therefore, they might not want to give their decision in open court if the decision favors the defendant. That's just my personal opinion. It obviously depends on the judge. There are some judges that are going to be perfectly appropriate, perfectly fine saying, yeah, not guilty. And that's the end of the case. And, you can at that point walk out with a smile on your face. So anyway, if they offer you a chance to get your decision in the mail, I would take the decision in the mail. You make that call depending on whether you think what your chances are. If you think your chances are better in court to get a decision right then no, I wouldn't waive my right to a decision today. But I don't think you have a right to a decision right then in the courtroom. It might be by the end of the business in the court day or some other time. That particular calendar day, I believe, is what you have a right to. A decision on that calendar day. And let me say one thing about generally your attitude in court, or what you should think about, how you should think in court. Part of the problem is that for most people, court can be a very intimidating place. And really, if it's not an intimidating place for you, you're probably not normal. You probably have something wrong with you. And that's fine. But, the average person doesn't like going to court, doesn't feel positive about being in court. And so they don't want to be there. And furthermore, they might be wasting time. They might be missing pay off of work and all that stuff. But basically, they might just feel unsure or uncertain. And if you've researched your case, and if you know the law in your case, you can find out in a matter of 10 or 20 hours online quite a bit about the law in your case. And if your case is a red light camera case and the fine is $490 plus $190 for traffic school, if you are able to go to traffic school, that's still almost $600. In fact, with court fees and traffic school costs, it will be at least $600. But you can take traffic school online or whatever, but it's still going to be at least $600 by the time you're all finished. So to me, it's worth challenging. I remember the last court case I was involved in Ventura, in the city of Ventura, in Ventura County. And this was a case I eventually won. And this judge was a judge I disqualified under Penal Code 170.6 peremptory challenge. And it is peremptory, by the way. It's not preemptory. It's peremptory. It's the same challenge that goes with a juror when a lawyer disqualifies a juror, for example. Same word there. But I disqualified this judge, and he was angry about it. He was really angry about it. And he wasn't yelling and screaming at me, but I think he was verging on unprofessional in his opposition to my motion, which was 170.6 motion, which he really doesn't have any discretion over at all. And he's required by law to allow that motion. Now, there was a little bit of confusion, though, too, because I had previously disqualified a judge on another day, like 30 days earlier in the same case. I disqualified a judge as a pro tem, temporary judge, so basically a lawyer playing the part of a judge, but not really a full judge in the case. And you have a right to a trial before a full permanent judge in your case, not a temporary pro tem judge. And you have a right to one peremptory disqualification. And I believe that's Penal Code 170.6, so you can look that up and see what I'm talking about. You don't have to say why you're disqualifying the judge. You don't believe the judge is going to be fair or whatever. And whatever reason you have for that, Madam Cleo might have told you that on TV. Whatever reason you have is irrelevant. If you believe the judge will not be fair in your case, you can disqualify the judge. Now, for me, I wouldn't disqualify any judge if the officer failed to show up. If the officer fails to show up and they call your case, then I wouldn't disqualify the judge. But if the officer does show up, and hopefully it's late in the court day, then I would disqualify under whatever method you can. It's either going to be the pro tem temporary judge disqualification, or it's going to be PC 170.6. If the officer is there and ready to present their case, I would disqualify on the hope that they'll continue the case to another day, or the judge will dismiss the case at that point because there aren't any more judges available that day, or whatever it can be. I don't know what the ramifications are on that. There is that question of whether you're eligible for if you're you're guaranteed a decision that day in court. I think that the courts believe that it's bad for people to miss work 2, 3, 4 times or whatever just to deal with a traffic ticket. So they're not going to tell you, hey, the officer's not here, we need you to come back the next day. If they can't find a judge in the courtroom that day, a full judge that can hear the case that day, I don't know whether they are required to dismiss that day based on the fact that you have a right to a decision. Okay, that's something, if you want to talk to a traffic attorney about or look that up, by all means, go ahead and look that up. One thing I think I did cover that earlier. Actually, I did. So anyway, that's it. If you do have a case, pursue your case, educate yourself, and then present your case in the best way that you can while being respectful and being persistent throughout the process. Good luck.